Barbara McQuaid, I'd love to get your reaction, first of all, to the decisions, but also everything Ken just said. Don't the justices know that when they're kicking it back or when they're pushing it to the very last day and doing all these different things, that they're actually giving an outcome to this? It's not that they're leaving this undecided and kicking it back to the lower court. They're actually making a very clear decision that impacts the way Trump would behave as president again, or someone else.
Yes, in fact, you may recall Jack Smith asked the court to take this up back in January. He said, look, this case is going to the Supreme Court anyway. There's no reason for us to take a pit stop along the way at the Intermediate Court of Appeals. So why don't we just go directly to the Supreme Court and decide this case now? And the court said, no,
right.
let's let the Court of Appeals make its choice. And when the court wants to, it can act with urgency. We know in the Nixon tapes case during Watergate, the court made the decision 16 days after oral argument. Here it waited for more than 2 months. And so it is a de facto delay and victory for Donald Trump, because the trial most certainly will not take place now before the election. But getting back to some of the things that Ken said, I think this case is going to survive because there are a number of unofficial acts alleged in the indictment: the gathering of false slates of electors, the pressure on people like Brad Raffensperger, the public statements may be in about a stolen election. So I think this case will survive. What I'm actually more worried about is the future of the presidency, where, as Ken said, anything that is framed as an official act now is not prosecutable. And so, as Justice Sotomayor says, the president could literally order SEAL Team 6 to assassinate a rival and cannot be prosecuted for that. That does leave some recourse, but that only recourse is impeachment, which requires 2/3 of the Senate to convict. And in our polarized times, as we've seen, that has become a virtual impossibility. And so I really worry now about the weaponization of government.
Yeah, and without a doubt, these have been pushed well past Election Day now, so will not factor into the campaign, which leaves now the question, Secretary Johnson, of what it means for a sitting president, any sitting president right now, in that murky area we've been talking about this morning between an official act and a personal act or a private act. How do you define that, which is a question now Judge Chutkan gets to answer as she goes through the evidence in that case.
It's complicated, and my guess is that it will take months, if not years, to sort out through the district court, through the appellate process. I took constitutional law 45 years ago, and I think I must have missed the lesson where my teacher said there's this provision in the Constitution that says presidents have criminal immunity from criminal liability. The framers of the Constitution knew how to write immunity into the Constitution, the speech and debate clause, which gives immunity to legislators for things that they say. No such provision exists for the president. If this doctrine has existed all along for the last 235 years, then Ford didn't need to pardon Nixon. And when Nixon said to David Frost in 1977, in an unguarded moment, when the president does it, it is not illegal. We were all shocked. We were appalled. It was an extreme statement. Turns out 5 justices of the current Supreme Court agree with that. And, you know, people like to cite the Anwar al-Awlaki case. I was there. I was the senior legal official for the Department of Defense, September 30, 2011. The executive branch is functioning like it should, and you have a legally controversial action, such as that counterterrorism action, the action works its way up through the chain of command. Every person in the chain of command has a lawyer. It's signed off by the General Counsel of the Department of Defense, the General Counsel of the CIA. In Alaki's case, the Department of Justice Office of Legal Counsel. So by the time it gets to the president, every lawyer has signed off on it, and the president is therefore acting consistent with law. There are built-in safeguards for that. It is only because now, 235 years in, that we have a past and possibly future president who engages in criminal conduct that we have to have this debate. And at least 5 justices on the Supreme Court feel the need to try to protect him. This is, to me, an unbelievable decision. And in my view, it's a setback to our constitutional order.
Yeah, Jen, funny, isn't it, how over the course of 235 years, no president has needed to consider this question. But now with Donald Trump in front of us, the court has.
Yeah. And I mean, it's like there are niceties and details here that really matter, but also at some level, I just think this court is going to do whatever this court will never say no to him. I mean, that, you know, but you were cabinet secretary, so you just laid out how sort of the safeguards ensure that the government is operating within the bounds of laws, and using the Alaki case as an example. But, you know, are there other examples from your time as DHS cabinet secretary where you would think, okay, if there are no longer these guardrails of worrying that the president is somehow criminally or somehow legally liable, you know, what might that mean?
Well, first of all, from the perspective of a cabinet officer, how's this supposed to work? Suppose the president says to the Secretary of Homeland Security, I am ordering you to order the Border Patrol to go shoot at migrants swimming across the Rio Grande. And the cabinet official would rightly say, well, you have immunity, but I don't. So you go do it yourself. I'm not telling the Border Patrol to do that. How is this supposed to work? So I don't understand how the implementation of this ruling is going to work, and just the process of separating out what's an official act, what's a quasi-official act, what's an unofficial act, and the proffer of evidence at a trial court is going to take. It's going to be a trial in and of itself, and then there will be an appeal following that. And so this is a real setback.
Yeah, and Ken Delaney, as the Secretary says, every piece of evidence that Judge Chutkan says, well, that was actually a private act, Donald Trump's team is going to challenge that. And here comes another hearing and another setback in that case and pushing it down the road. You touched on it briefly earlier, but what's your sense of the implications for Georgia, for the case there, a state case, and the other federal case down in Florida with Judge Cannon?
For Georgia, it seems to have the same implications of the January 6th case here, because it's the same conduct, essentially. So they'll make the same claims, and they'll say that almost all of it was official acts. During the oral arguments, Donald Trump's lawyer said he didn't think the January 6th indictment could survive if the court ruled as it did here. And then in the classified documents case, you can see them making an argument, the Trump team, that if those documents were taken from the White House while Trump was president, which I believe most of them were, then that was an official act. Donald Trump was simply taking his presidential records, and everything that came after that, including the allegations of obstruction of justice and destruction of evidence, all that is moot and can't be part of a prosecution. And so, yeah, it raises a whole ton of complexities. You know, I think back to Watergate. A lot of people have been talking about Watergate, and does this mean that what Richard Nixon did, he would have gotten a pass for? I think it's more complicated. I mean, clearly when Nixon ordered the CIA to shut down an FBI investigation, he would have argued that was an official act. But covering up a burglary of the Democratic National Committee by private individuals paid through a slush fund, I don't know. If you read this decision, it does leave some room, particularly for presidents acting as a political candidate. That, I think, is still yet to be litigated. That's why I think it may not be quite as extreme as some people are saying. And also, what Jay Johnson just said about why a cabinet secretary wouldn't follow an legal order is, I'm comforted by that. That's kind of a safeguard for why some of these extreme scenarios perhaps aren't going to come to pass. But nonetheless, it opens a lot of scary doors here, I would say, guys.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.